So good evening and welcome to this joint event from LGBT Labour and the Society of Labour Lawyers for LGBT History Month, titled Inclusive Families Are the Laws on Adoption, Surrogacy and Families Working for the LGBT Community. My name is Joe Vinson and I am the National Secretary of LGBT Labour, and I also work for the Society of Labour Lawyers, and I will be your chair for this evening. Tonight, we will be looking at the history of LGBT rights in adoption, surrogacy, and more generally in family law. And in addition, I'm sure we will touch upon Labour's record in government in this area, as well as identifying the barriers faced by the LGBT community in adoption and surrogacy proceedings, and what the next Labour government could and should do when it wins the next general election in 2024. We have a fantastic panel this evening covering the legal and the political, and I'm excited to introduce them to you in order they will be speaking to you tonight. So we have Tulip Siddiq, Shadow Minister for Children and Early Years and Member of Parliament for Hampstead and Kilburn, who is joining us for a few minutes to start the event. We have Andrew Powell, Family Law Barrister at 4PB, author of A Practical Guide to the Law in Relation to Surrogacy. So if you haven't got your copy, please buy one. Andrew specialises in surrogacy law and has appeared in some of the most notably recently reported cases in this area. Chambers and Partners says of Andrew, his knowledge of surrogacy law is utterly amazing and his passion shines through. We're also joined by Naomi Angell, co-chair of the Society Labour Lawyers Family Group and family law solicitor at Osbornes, recognised as one of the most experienced adoption and surrogacy lawyers around. She recently won the Law Society's 2020 Lifetime Achievement Award. We also have Dr. Charlotte Proudman, Family Law Barrister at Goldsmith Chambers. Charlotte is renowned for her experience in surrogacy and adoption, and is also a Junior Research Fellow at Queen's College, Cambridge, and researches and lectures in gender inequality under the law. And finally, we will hear from Norris MP, Shadow Minister for Public Health and Patient Safety and Member of Parliament for Nottingham North, whose brief includes surrogacy. So as always, after our panel have spoken, we'll be taking questions via the Q&A box at the bottom of the screen. I can't promise we'll get through them all, but we shall certainly try. So please do submit them throughout the event, and you don't need to wait for the Q&A section to begin to do that. But without further ado, I would like to invite Tulip Siddiq MP to start off our panel discussion. Over to you, Tulip.
Thanks very much, Joe. And thank you very much, LGBT Labour, for organising this fantastic event. There's an amazing range of speakers and for inviting me to speak as well. And as Joe's just said, I'm Tulip Siddiq. I'm the MP for Hampstead and Kilburn, and I have been since 2015. And I'm Shadow Minister for Children and Early Years, which means that I lead on adoption for Labour, and that's what I'm here to speak on today. I joined the Labour Party for many reasons. I joined because of our record on equality, on fairness, of social justice. And when we talk about the last Labour government's proud record on LGBT rights, we rightly highlight the crucial and long overdue steps forward, like abolishing Section 28 and introducing civil partnerships. But I do feel that it's less talked about. But just as important was the equalisation of adoption rights in the Adoption and Children Act 2002, something that broke down yet another barrier for LGBT people in this country and allowed many more couples to follow their dreams. This legal change sowed the seeds for a slow but decisive transformation. 15 years ago, less than 3% of children were adopted by a same-sex couple. By 2019, that figure stood at around 14%. This is a massive increase that reflects the real progress that has been made in attitudes, and we can all celebrate what it means for the adoptive parents from the LGBT community and the many children who now have a safe, secure and loving home to call their own as a result. But the truth is, and I'm sure everyone on this discussion knows that, we can't ever be complacent. And there's still a lot more to do to ensure that all LGBT people who want to adopt or foster can do so and know that they will still get all the support that they need. A report that I recently read from last year suggests that 1 in 7 LGBT people are still finding that their sexual orientation is a barrier in the adoption process. And we know that many more prospective adopters and foster carers who are LGBT think that they will face barriers because of their sexuality. Having been on this brief for a long time, I know just how emotionally taxing the whole process can be. And yes, very rewarding at the end, but it still is very emotionally taxing for the couples to go through it. But if they have an additional barrier that they think that they'll be penalized because of their sexual orientation, that's something in this country that we've got to get right. So while the law in this area is no longer a fundamental barrier for LGBT plus people, we need to make sure that adoption and fostering agencies have the information, the guidance, the systems, the training and the scrutiny to ensure that the needs of LGBT plus applicants, the parents and carers are met and that they're met properly. And clearly there's work to be done to address the hesitancy that still remains for some in the LGBT plus community based on negative experiences with public bodies and fear of discrimination. There's been several cases that I've dealt with since I became an MP where this topic has cropped up. And to my embarrassment, it feels like I can't say to the constituents who come to me and talk about their experience that next time it'll be much better. I can't say that with full confidence because it hasn't changed in all the time that I've been an MP. So what I can do is hold these public bodies to account. I can make sure that the fear of discrimination diminishes over time. It's something that I will continue to champion from the Labour front bench, and I have been raising other issues in education like the cuts to anti-LGBT bullying programs, which should really make our heads hang in shame. I'm really sorry that I can't stay for the rest of the event due to a prior commitment, and I was just saying to Joe that for some reason this evening seems to have lots of events, so I've got to rush to another one. But I do want everyone on this discussion to email me if there's particular things they'd like me to raise. There's only one MP called Tulip, so you'll find me very easily, but I'm tulip@tulipsiddiq.com. Do email me because we're starting what's called the big conversation from my shadow ministerial team around children and early years. And I definitely want adoption, issues of the LGBT community and fostering to be a big part of that conversation as well. So thank you once again for giving me the opportunity to speak tonight. Let's keep in touch and let's work together to achieve true equality in law and in society. And when we have a Labour government, and I'm confident we will have a Labour government, this is not based on anything except my own feelings, but when we do have a Labour government, I want to make sure that we get this policy right and that we make life so much easier for all those parents who had to face so much discrimination in addition to everything they have to face when they go and adopt and foster. So thank you, Joe, and thank you everyone on the panel.
Thank you very much, Tulip. I know you've got to rush off now, but some extremely salient points there, including how 1 in 7 LGBT adopters still feel like they're facing barriers in their adoption process. That's very interesting to hear, and I'm sure something we'll touch upon later on in the event. But thank you very much for joining us, and we hope to see you soon. Next on our list of speakers is Andrew Powell, who's a family law barrister at 4PB. Andrew, over to you.
Thank you, Joe, for inviting me along to this very important event. I think just looking at surrogacy specifically, it's what Lady Hale described it in a Supreme Court judgment at the end of 2019 as a fragmented and obscure area of law. And that's despite having had almost 35 years of legislation, but it still seemed to be fragmented and obscure. And before I talk about the current legislative framework and how that impacts on LGBTQ plus people, just looking at the history of surrogacy, there wasn't really any law before 1985. And it was only when there was a case called Baby Cotton in the 80s, where an English woman who was effectively commissioned by an American couple to have a child for them on a commercial basis, caused a bit of a political and moral storm in the 80s that it was seen as baby buying. So the implication of that case was very much a knee-jerk reaction from the 1980s government, as you can imagine, to prohibit commercial surrogacy. And it pretty much made surrogacy taboo thereafter. And it was only in the 1990s that following that case, there had been a commission set up, led by Baroness Warnock, that looked at generally human fertilization and embryology. And so the 1990 Act of the 1990 Human Fertilization and Embryology Act created a framework where if you had a child through surrogacy, you could be recognised as parents, because the thing that gets very confusing and quite complex is that the woman who gives birth to a child is always regarded as the child's legal parent, regardless of whether she is related to the child biologically or not. So if it's not her eggs, but it's somebody else's eggs, she's still seen as the legal parent. And indeed, if she's married, her husband is seen as the legal parent as well, even if it's not his sperm that was used to create the embryo. So the 1990 Act created this type of bespoke order called a parental order, which is a bit like an adoption order in that it extinguishes permanently the legal right of the birth mother and her husband, and transfers it to what we call the intended parents. But the difference between between a parental order and an adoption order is that the parental order is a order that is intended to reflect what was always intended, whereas an adoption order is replacing parenthood for whatever reason a child may have been received into care and then subsequently placed for adoption. So the 1990 Act set out a criteria of who could apply for such an order. And of course, it's in the 1990s, so it's inevitably steeped in a very much a heteronormative model, in that only married opposite sex couples could get it. Of course, in 1990, only opposite sex couples could marry. But if you were single, you couldn't apply for a parental order either. So there's a barrier there from the outset. There are a number of other criteria which you have to satisfy as well, such as domicile. You have to be living domiciled in the UK or the Channel Islands. You have to be over 18. You have to have your home with the child when you make the application. You have to have the consent of the surrogate. There are various other criteria which you have to go through. But that Act remained in force pretty much until 2010, when the 2008 Human Fertilisation and Embryology Act broadened the scope for who could apply for a parental order. And that made it possible for cohabiting couples to apply for a parental order if they could satisfy or demonstrate that they were in an enduring family relationship. It also allowed people who were in a same-sex civil partnership. Of course, 2010 there was no civil same-sex marriage at that stage, but it didn't allow for single people to apply for parental order. So it broadened it. It allowed, opposite sex or same-sex couples who were cohabiting, or people who were in a civil partnership, but it didn't allow single people to apply for parental orders. It meant that if, for example, you were a single man, gay or straight, frankly, and you went to another jurisdiction to have a surrogacy arrangement, and you came back to England to say, I've got this order from California that says I'm the parent, but as I understand it, I'm not still recognised as a legal parent here. And I think that's probably an important note to recognise, that even if you have an international surrogacy arrangement, which are predominantly the cases that I deal with, if a competent court in the Ukraine, in America, in Mexico, in India, has made an order that says you are the intended parents, you're not automatically recognised as parents here. You still have to go through a process here. And that's even in cases where you may have an opposite sex couple who use each of their gametes, but you're still not seen as a legal parent here until you apply for a parental order. So if you were a single man, the 2008 Act didn't allow for single people to apply for it. And there's an obvious parallel there to single women who can use IVF treatment, or single people who, under the Adoption and Children Act 2002, can also adopt. So there's a bit of a disparity there. And it was only until 2016, when there was a case which that I was involved in representing the child, where there was a human rights case that tried to challenge it under the Human Rights Act, seeking a declaration of incompatibility to say it's incompatible with human rights not to allow a single person to apply for parental order. And that case happened in 2006, and 2016, and the remedial order that changed the statute to allow single people who are biologically related, so i.e. if you're a single person and it was your gametes that were used, you can now apply for a parental order. But it was only changed in 2019. So obviously between 2016 and 2019, Parliament was quite busy with other stuff, as you can imagine. So it took a while for it to come through. More broadly, so where we're at today, there has been intense interest from the Law Commission, who is an independent body to government, who review areas of law that may require reform. And surrogacy has been under the spotlight since about 2017. And one of the proposals which they made in 2019, although it's not been followed through yet, it takes quite a long time to get through. But one of the proposals they've made is to introduce a pathway that would allow intended parents to acquire parental status sooner. And I think part of the ambition of that, and I don't think I'm preaching anything by saying this, but I've been involved in some of the Law Commission consultations about it, where they have sought input from practitioners who are seeing it on the ground. And I think one of the reasons why they want to create a new pathway, which would allow intended parents to acquire parental status earlier, is because there has been a perception, and I think it's not really a perception, I think it's the reality, that people are often put off from pursuing surrogacy in this country because there are fewer surrogates available, and there's also this sense of legal uncertainty that we won't be seen as the parents. And when you say surrogacy, people often think there's going to be a dispute between the surrogate and the parents. The impact specifically to LGBT parents is that there are often jurisdictions which are just not LGBT friendly. I've had cases involving Russia where it's prohibited if you're a same-sex couple to pursue surrogacy. So I think part of the Law Commission's ambition is to try and encourage people to stay in this jurisdiction and pursue surrogacy here. So this new pathway which they're proposing to introduce would mean that at birth, if you satisfy certain criteria, which I won't bore you with, but if you satisfy certain criteria, it would mean that you'd be recognised at birth as the parents without having to go through a more protracted process. And I think looking at the numbers, and again, I think a positive thing when we're looking at it within an LGBT paradigm is that there's a really big push that recognises that surrogacy is a legitimate way of creating families. And in fact, that's one of the things that's said in the Law Commission's report, that it is a legitimate, sensible way to do it, but we need to protect people, because there's also a flip side of there being concern about things like exploitation. So for example, there are certain jurisdictions which intended parents think are more favourable because it's cheaper, and they go there and say, for example, if they're a same-sex couple and haven't done their research, they then get stung and they're left in difficulties, and it can cause immeasurable problems, which Naomi, Charlotte and I have all been involved in those cases, where it gets immensely difficult and you're having to find solutions in a very, very difficult circumstances. And I think what the Law Commission's aim is really to create certainty, and perhaps also to avoid and prevent there being the risk of people going to countries where they're at risk. And I think the one thing I perhaps would say, well, I've got Alex's attention, is to say there's a parallel here with adoption. In adoption, there is a list of countries. I mean, adoption's complicated from an international perspective, but within the adoption rules, there is a provision under a 2013 order, which says that if you adopt from this particular list of countries that is recognised by the Home Secretary as being a country where they're happy with the adoption process there, your adoption order is automatically recognised here. A similar thing could perhaps happen with surrogacy, and that would probably help a lot of families, in particular LGBT families. So it would mean you would go to somewhere like California, and if the US was on that list, you wouldn't have to go through the process of applying for a parental order. So that's probably perhaps one thing to consider. And I think that's certainly at least 10 minutes. I should probably stop.
Thank you so much, Andrew. I mean, it's fascinating to hear all of that, particularly about how the law even now is still evolving, even up to 2019, and how I'm sort of getting the impression that it's kind of a patchwork and it's a bit of a mess, really. So I'm pleased that at least Alex is here from the front bench to hear that firsthand. Next up, we've got Naomi Angell, who I think will be talking to us about adoption predominantly, but perhaps also on surrogacy, who is a solicitor at Osbornes. So Naomi, over to you. I believe you're muted at the moment. I'm trying to unmute.
Fine. I want to look back just very briefly to dramatic changes in the concept of family that I have seen since beginning to practice as a children's lawyer in the 70s. In the 70s, I had cases where women separating from their husbands and coming out as gay would lose their children in a custody dispute, regardless of the child's welfare, which was pretty horrendous. I'd had cases where actually the woman, once the report came up from the official solicitor who was supposed to be representing the child's best interests, would actually come down against her. And so everything was loaded against her. But this has changed. Now, heterosexual two-parent families bringing up birth children exist alongside families with very different lifestyles, sexuality, and gender. In any school class, there could be children with cohabiting gay or straight parents, stepchildren and half-brothers and sisters, children adopted, fostered, or born by surrogacy, to gay and single-parent families, straight, gay, and single-parent families, and children born by assisted reproduction. Now, when I'm giving legal advice to families who are right at the beginning of this journey, what on the alternative pathways to parenthood for them, what is important is that they fully understand what's involved in each way forward, and each individual and what they feel comfortable with in their chosen route. Each individual and each family is different, and the decision they're making will be the most far-reaching and life-changing of the decisions that they're going to make in their lifetime. So this evening, I want to focus on the adoption by LGBTQ plus families to bust some of the myths and throw some light on what lies behind those myths. Firstly, can gay families adopt? Can LGBT families adopt? Well, along with the new law that came in on surrogacy, the 2002 Adoption and Children Act really changed the landscape of who can adopt and broadened it right out. So now married, straight or LGBT families can adopt, families cohabiting who are in an enduring family relationship, single people, people in a civil partnership. I think I've covered everybody, but maybe not. I might have missed out some people. The central factor is the suitability of adopters for each individual child. And the overarching concern of adoption agencies and judges must be that the child's paramount best interests must be met throughout those children's lives. In the Act, in Section 1 of the Act, apart from that overarching provision about the child's best interests, there's a checklist of factors that have to be considered when adoption agencies, children's guardians, and judges are making any decision about a child and adoption. The number of LGBTQ families adopting has reached an all-time high in 2020, according to DFE statistics, while the overall number of adoptions in England has fallen. The DFE stats show that there were 490 adoptions by LGBT families, and that was 1 in 7 of all recorded adoptions for 2018-2019. Now, before we came on, Joe said he'd heard there were lots of LGBT families who'd been assessed as suitable, but then have been hanging around for ages to be matched with a suitable child. Now, I don't know, Joe may have more information about this than me. I've certainly seen the landscape changed, but the problem is that often legislation, however well-meaning, does not cascade down into practice, and that may well be the case, but I think it's something worth us exploring. What I do know is LGBT families are going to face a more welcoming reception with the voluntary adoption agencies than they are probably with the local authorities and the regional adoption authorities, which are sort of consortiums now of adoption agencies. Reasons for the fall in adoption numbers generally are complex, and I'm not going to explain them now, but if anybody wants to ask a question about that, I'm very happy to talk about that. Although sorry, find my place in my, sorry. So although the landscape is far better for these inclusive adopters, it's not so rosy in relation to same-race adoption. There was a change in the law in relation to this in 2014 with the Children and Families Act, which provides that in matching a child for adoption, same race, culture, and heritage of a child to prospective adopters must be just one of the factors in the decision making, but not the trump card, as it had been up till then. However, as may well be the case with LGBT adoption, it's my experience that this new law hasn't always cascaded down into social work practice, and that race, etc., are still often overriding factors for social workers in matching children for adoption. The whole aim of this was that there were so many children lingering in the care system, being abused by the care system as much as they may well have been by their parents, that they became unadoptable because social workers were waiting for that perfect match. And also there were too few mixed race Black adopters, BAME adopters in the system. So that came with also a drive at recruiting a more diverse pool of adopters. I move on now to the myth of, can birth parents stipulate that they do not want their child to be adopted by an LGBT family, that's when the birth parents' views are sought by social workers on a proposed adoption of their child. Now, the 2002 Adoption and Children Act and the associated 2005 adoption regulations provide that the adoption agency, when deciding on matching a child for adoption, must, so far as is reasonable and practicable, ascertain the wishes and feelings of the parental guardian of the child. Also, one of the sections in the welfare checklist to section 1 of the 2002 Act, which I've already mentioned, is that adoption agencies, sorry, my computer is playing up. Sorry about this.
No problem, Naomi.
Yeah, that again, the paramount interest of the welfare checklist says the paramount best interest of the child and the wishes and feelings of any relatives of the child must be taken into account. And this is specifically in relation to those birth parents' wishes and feelings about the child's religious, cultural upbringing, race, etc., when adopters being chosen for a child and matched with them by the social workers. But again, this must not be an overarching factor, no blanket policy, but just one factor in a very complex decision-making of what family can best meet all a child's needs in their new family for life. Even if a child cannot be matched with a family of the same background, the prospective adopters would be, in the course of the assessment procedure, which I'm going to explain to you in a bit more detail, they'd be asked how they would address, inform, encourage, and support a child in having pride in their heritage and their background integrated into their upbringing of their children. Now, the last myth that I want to debunk is an inclusive couple or family likely to encounter prejudice during the assessment by an adoption agency of their suitability to adopt? Just very briefly, if I can explain the assessment process, is that the first thing that you do if you're interested in adopting is phone your local authority adoption unit or the new consortiums, the registered adoption agencies, and express your interest in finding out more about adoption. You would then be invited to attend an introductory meeting where you would learn more about adoption generally and the sort of children who would be available for adoption. The next stage, if that family decide that they want to go further, is that checks will be taken on. That's medical checks, DBS checks, local authority checks, and if either of a couple or if a single adopter is from another country, they'd be the equivalent of DBS checks in that country. Then if the family satisfy the adoption agency in that respect, and they still want to go forward, they would attend something called a preparation course. And that's 2 to 3 days when they learn much more about adoption, much more about the sort of children available for adoption, helping them to look at the children they think might best be able to meet their needs. And also issues such as attachment difficulties, the challenges that children from adoption might encounter. And they then, if they go past, if they decide then that they want to go to proceed further, stage 2, they go into stage 2, which is the allocating of a social worker to them, who with the family will embark on the detailed home study report. Now, I've heard many people say, this is intrusive, why do I have to do this? Both parents don't have to do it when they're thinking of having a child. But the reality is, it's a risk assessment as to whether a prospective adopted family are likely to be able to parent a child successfully and safely into parenthood. And that includes a whole range of factors, such as the adopter's health, likely stability of their relationship, realistic aspirations for their child, and how they deal with challenges that the child might encounter in growing up. So yes, it is robust. Yes, it can be seen as intrusive, but these are not children you're giving birth to. These are children who've actually had to leave the care of their parents for a variety of reasons. Their incapacity, it could be because physical abuse, sexual abuse, neglect, and these children could well face additional challenges in their behaviour in growing up. So they sort of need extra special parenting. Now, sexuality would be a factor to consider and address in the process of the adoption, but it would only be one factor. And it's likely, well, one hopes, rather than based in prejudice, approach it from an angle of what happens if your child faces prejudice because of the sexuality, gender of their adoptive family in the school environment, either from parents or maybe from children. And again, it's an opportunity to address issues like that. Now, people are, as I said, they complain about the home study process and the necessity for it. But if you have a good relationship with your social worker, and you can really share things together, going through your childhood, your family background, and then looking forward to bringing your child up, it can be both an educative and very helpful process. Birth parents don't have an opportunity to look forward to a child's adolescence and what will happen if they're questioning everything. They don't meet the aspirations or plans that family had for their children. And the home study process will hopefully give an opportunity for that to happen. So I'm going to finish now and hand over to Charlotte.
Thank you very much, Naomi. I mean, it's fascinating to hear all of the hoops that any adopter has to jump through, let alone LGBT couples or even individuals. And it's one of the reasons why I'm so pleased we're having this event this evening, because it's not often talked about, particularly in the Labour Party. So thank you so much. And there are some things in there to celebrate, including the fact that 1 in 7 adoptions are now by LGBT couples. I know it's not necessarily recorded for individuals necessarily, or for whether there's an LGBT person in a mixed sex couple. So good to celebrate that, but also I think some areas to explore more in your remarks later on. So thank you so much. We'll now move on to Dr. Charlotte Proudman, who is a family law barrister at Goldsmith Chambers.
Thank you so much, Joe, and thank you to the LGBT plus Labour group for inviting me to speak with you this evening amongst such renowned speakers in the field of surrogacy and adoption. I wanted to speak with you a little bit about international surrogacy arrangements. And Andrew touched on this earlier when he spoke about how sometimes surrogacy arrangements can go wrong, and he touched on exploitation that can occur in other countries and some of the immeasurable problems that can flow from that, and the importance of trying to find solutions to very difficult and often extraordinary circumstances, sometimes very sad to say. And I wanted to do that by speaking about a particular case that I was involved in that has been published, so people can look that up at their leisure if they so choose. And I think it's just important to kind of provide a bit of context to how these cases can evolve and unravel. So those listening can just have a real, I suppose, a real understanding and flavour about what can happen in people's intimate private lives and the kind of cases that we come across. So this case is Re-CA Child, Parental Order and Child Arrangements Order 2020, EWHC 2141. I'll put it in the chat box later so people can always look it up. And it really was quite an extraordinary decision, and it happened after a lengthy hearing, what we call a fact-find hearing, in which it was found by the High Court, a High Court judge, that the mother in this particular case had lied about the father's consent to a second surrogacy arrangement, in which she had gone about commissioning, in this case, in fact, it transpired to be 2 twins, or what we say a twin, had been born. So just to give you a little bit of background on this case, the mother and the father, they were both married, and they'd entered into a surrogacy agreement abroad. This was some years ago, and flowing from that, at the time, they had a 2-year-old son who was born out of this surrogacy arrangement. And as I say, this did take place abroad, so outside of the UK. Now, the mother, who was also part of commissioning the surrogacy arrangement, had asked the surrogacy agency abroad to continue storing the father's sperm. And she asked her to do that for a further 5 months. Now, soon afterwards, the mother then entered into another surrogacy agreement, a second surrogacy agreement with the same surrogacy agency abroad. And that second surrogacy agreement was signed with the proposed surrogate mother, which was different to the surrogate mother for the first child. And the agency's lawyer had signed the agreement on behalf of the parents using a power of attorney, which was used the first surrogacy agreement. So far you think that sounds fairly straightforward. An embryo was then implanted into the second surrogate mother, and the mother became aware that the surrogate mother had become pregnant. Now, the father had said he was unaware of the second surrogacy agreement, and he did not sign the second surrogacy agreement either. And there was some argument about whether it was his signature on the surrogacy agreement or not, and so forth. But that was what he had said had happened. And following this, twins have been born as a result of this second surrogacy, and they remain living abroad. And I'll come on to some of the difficulties arising from that from an immigration perspective. I also practice immigration law now to a more limited extent, but I do have knowledge and experience in that area, and speak about some of the difficulties that can be encountered thereafter on trying to bring children back into this jurisdiction. So in any event, they'd remained living abroad, and at the time with mother and with alternative carers, until they eventually arrived in this country. And it was very difficult for them to come to this country, as you'll see from the challenges that flowed thereafter. Well, the High Court judge looked at all of these circumstances, in particular that the father had said that the mother had lied about the second surrogacy arrangement, and in fact he had never consented to that. And what Mr. Justice Keehan said, and he made very significant and serious findings, is that he said, I was not satisfied that the father had signed the second surrogacy agreement, and I found he did not. He also found that the mother deliberately concealed the second surrogacy from the father to a point in which it was too late for him to then do anything about it once he discovered the surrogate mother was pregnant. The father did not consent to the extension of the period of storage of his genetic material by the surrogacy agency, which again was abroad. And in fact, there were real concerns as well about the surrogacy agency and their credibility when they gave evidence during the hearing, and whether in fact they were aware as to whether the father had in fact consented to the second surrogacy arrangement. And, you know, I think it's important to note that from this case, of course, not all cases go terribly wrong, and Andrew and Naomi and I only tend to see the ones that do go horribly wrong often. So, you know, there are many others which, of course, don't have anywhere near the same difficulties as have arisen in this case, and many others that we've touched upon. But international surrogacy arrangements are believed to account for up to half of surrogacy arrangements entered into by UK-based intended parents, which is a significant number surrogacy arrangements. And we've heard about the patchwork of surrogacy laws and policies and different interpretations of the laws that we have, and how case law has slowly evolved, slowly but surely. And when looking at what's happening actually internationally, I think that is where there's a real grey area in terms of whether the surrogacy agencies themselves are even regulated, and how one may be able to even make sure that they are, for example, imposing checks and balances of a nature where one is ensuring that where the sperm is being stored, that individual has actually consented to that, and for a specific period of time, without the continuation of their consent being presumed, or in some circumstances potentially being duped. Because of course in this particular case that I mentioned of Ree, that then led to the birth of twins, and consequently, as a result of that, the father of course said that, well, he had no role to play as such, and that he wasn't even aware of this having unfolded. The mother that had commissioned this, as it appeared unilaterally, she technically, of course, was no biological relation to these children, and was in real difficulties in being able to bring those twins over to this jurisdiction. And when it comes to immigration law, we know that there are two formal routes to allowing children born of an international surrogacy arrangement to do this, and one is within the immigration rules, and it relies on having one intended parent who is recognised as a parent under the UK's law on nationality, which of course in this particular case would be very difficult, if not impossible. And the other route operates outside the rules at the Secretary of State's discretion, and of course one will no doubt be aware of the history of having a rather hostile immigration policy in some cases. This has been applied even in surrogacy arrangements. And it relies on an intention to apply for a parental order once the family is back in the UK. And one can see the difficulties in the case of Ree, because the mother wouldn't be able to apply for a parental order in this particular case, and her route may indeed only be adoption. And a child could also enter the UK where it is acquired on birth citizenship of another country, the citizens of which do not require a visa to enter the UK, so for example the USA, but of course that doesn't apply to all countries. And so I think I just want to touch upon really, and I know it's such a short of time, already coming up to my 10 minutes, but the importance of recognising the growth of not only a market internationally, but also providing real solutions for parents, LGBT plus families and other families that do want to have children, and do so through the avenue of surrogacy. And doing that internationally can be very positive and beneficial for many families, but also recognising the need for more checks and balances. Thank you.
Thank you so much, Charlotte. I mean, absolutely staggering that almost a half of surrogacy arrangements are taking place abroad. I'm sure Alex will have listened to that very, very closely. And we'll turn to Alex to hear his opinion on everything the panel have said. So he's got quite a job, but we're looking forward to hearing it. Alex.
Yeah, thanks, Joe. And it's a pleasure to follow Tulip, Andrew, Naomi and Charlotte, and as you say, an awful lot to go at. And this is I think it's my third event with LGBT Labour in 3 weeks, so I'm really grateful that you keep inviting me back, and hope you will continue to do so. And my first with the Society of Labour Lawyers, so I hope they will consider inviting me again too, especially now that, given that Tulip's not with us at the moment, I consider myself to be setting policy not just for the health team, but for the education team too, which is the sort of unfettered power I've been seeking for a long time. So I just want to touch on the topics that we've discussed so far, talk about kind of where we are in terms of our front bench policy on our work in Parliament, and then keen to get friends' reflections on what we might do differently or better, or emphasise more strongly. So firstly, I wanted to start by talking about HIV, and I think it feels apposite to do so, given that we had a fantastic testing week. We're in this brilliant public policy position nationally where there's this common commitment across political parties to be transmission free by 2030. It was all wonderful. We were all, we had a week's worth of kind of vicious agreement, didn't we, Joe, on every issue, which is a wonderful thing. And that consensus is not inevitable, and that consensus has taken the suffering and the activism and the campaigning of incredible members of LGBT plus Labour over the years. So that's, we start as a good thing. However, we do still see, certainly in this space, some of the old kind of prejudices staying around. So particularly in the surrogacy space, that prohibition on someone who has a diagnosis but has their treatment has it down to the point where the viral load is undetectable. And for me, and for us from a front bench point of view, just as we said with blood donation, that we should be following the science rather than the stigma. And it feels to me that there's no evidential basis for the use of that. If there is, it's certainly not shared. And instead, it's I think if you were charitable, you'd say it's a lagging area of public policy. But I think I might, in my only bit of perhaps political attack in this, say that there is still a squeamishness around the government. And I think we've got a real responsibility as an opposition to push them on this in this public policy area. It's great to see in New Zealand that they have started to change this, and New Zealand in a lot of ways I think has things that we will look at as things that we would wish to do in government. So they're already ahead of us in this space, and we ought to be too. Whether it's blood donation, whether it's this area, whether it's PrEP, and the kind of the weird lagging period between people understanding the effectiveness of PrEP and PrEP being something that's rolled out, and even now today, something that's not available in all the spaces where people access their healthcare. There is a squeamishness around it, and there isn't a government minister sitting there tonight that doesn't think everything I've said is right. However, it's hard when you're waging a culture war on the one hand to then start to do things that look like they're particularly progressive, or they're more progressive than perhaps the population has been exposed to the information to understand that these are pretty obvious things to do. So I think we have a role in opposition to advocate strongly for those, and as I say, if we're going to be transmission free by 2030, yes, let's fight, and we intend to deliver that in government. Let's make sure we're stigma free a little bit sooner than that, and I think that's a good area for us to be pushing the government on. So on surrogacy and the surrogacy review itself, it's hard not to at least reflect on that the recommendations came out from the Law Commission, very constructive ones, I think broadly welcomed ones, but that's June 2019. So before we're going to see action, we're going to be approaching 2 years on that. And again, it's just this slowness. It's almost like either there's a sense that the government don't think that people are ready for these things, or that they don't think they've done the preparation work so that people are ready for these things, or it's just in the too difficult box or not a priority box. Now, of course, there's been a general election that time, we've had the COVID pandemic and Brexit, but in the meantime, these are things that are relatively easy to do. We as an opposition would be around the table to build consensus on this as readily as on any other issue at all. There's no politics in this for us. So, I'll be very keen to start to see some progress on that, particularly around the regulator. It was interesting to hear when Andrew was talking about some of the history. It's incredible that kind of piecemeal building on that has reflected the views of the government of the day and the views of the population of the day. I think some independence in the system would be a good thing. We would support that. Similarly, I thought everything that was said by multiple panelists around intended parents and that grey area or that transition period between being the intended parents to being the parents with all the paperwork, as it were, that there's a weakness in that, and there's anxiety in that, and that puts people off, which I think was the point Andrew made. So again, what the Law Commission said around changing that process and accelerating that point of having that legal status, I think could only be a good thing, and would be something that we'd be very, very keen to support. And just to make a few points on fostering and adoption then. I would, prior to Parliament, I was elected in 2017, and my 6 years prior to that, I was on my local authority. And I always, I never did children and families brief, I did adults and health for most of my time on my council, but I was always kind of struck with that awesome responsibility that the council has, and sort of on behalf of all of us as the citizens of Nottingham, to be the parents of, in our case, somewhere between, on any given day, about 560 and 600 children. It's an awesome responsibility to be parents to those to those children who have hopes and dreams and have potential and have, you know, just as much right and to access that, and we've got just as much obligation to make sure that they do. And I always stack this up, and you know, I'm in danger because I'm off my area of expertise of throwing around words that are easy, but I hope you'll see where I come from this. I think certainly Naomi, I think Charlotte also kind of nibbled around this also, but the process is really, really hard. And the process is really, really discouraging. And, you know, I'd be lying if I said I hadn't thought about it myself, me and my wife have spoken about it in the past. And I know, certainly in my lifestyle, as someone who works away from home most of the week, that's a problem straight away. And I feel like that's going to be a significant problem. I know, you know, of family friends who've adopted, in their case, it was it's the same-sex marriage. And the questions they were asked about parental history were extraordinary. And, you know, I absolutely believe, and of course strongly believe, that the process needs to be as safe as it possibly can be, and there's an obligation to do that, of course there is. But it also ought to be one that welcomes and supports and encourages people to come forwards, because for those, let's say 580 tonight, some of them will go back to their birth parents, but they will be very much the minority. Some of them will be adopted, but that will be a small minority also. The vast majority of them will be in, whether it's with long-term fostering placements, whether that's in some of the group homes that are operated by the council. They will be in those placements for their entire childhood. And, you know, those are places that the people who are doing that in my city are wonderful people, and the people who do it on behalf of the city council homes are wonderful people. People doing the voluntary sector are wonderful people, but the outcomes for those children are not good. And there are multiple factors as to why that is the case, but that common factor is there with all of them. And it seemed very strange to me that we would have loving families who want and are desperate to have a child in their family, and how hard it is. And it seems to me that in terms of system-wise, we have to find a way that we can safely do that, but is still without it feeling like an inquisition. But also, you know, if you were going to expand your pool of people who were wanting to do it, you would expand it into areas where traditionally they haven't been adopters, not because I would say that individuals haven't wanted to do so, but because society has tried to hold them out either by law or by custom and practice. So single adopters, you know, a really good prime example of ways in which people's lives are that would be under extraordinary scrutiny in that process. But it seems to me, you know, very much sustainable. You know, my family model is not a perfect family model. You know, I'm a single parent in a low income household. I wouldn't recommend it necessarily to a friend, but it worked for us, and it was a house full of love, and me and my sister have had a great life. That happens up and down the country every day, and that's entirely feasible in an adoption process too. And we have to be more. We have to move forwards and be a bit more progressive in those regards. But also around particularly LGBT marriages and partnerships, we know that stigma is there. I mean, you know, I was hoping to find an opportunity. This is probably the best opportunity to say, Joe, you know, people on the Zoom will have been as angered and frustrated as you can be about Luke Pollard and Luke's tweet over the weekend, and how that was treated. And what that was, you know, that mostly that took the form of a political attack, but that was people saying, your family doesn't look like what I think a family should look like. And that prejudice is there in politics. And they say, well, that's not what our leaders should look like, people were saying. But they weren't just saying that. They're saying, we don't want your life to look like that at all. And that permeates, and we have a real responsibility by, you know, being very clear in leadership and direction, whether that's Labour in local government where we hold power in cities like Nottingham, whether that is Labour in government as we hope to be as soon as possible, being very, very clear about the fact that families come in all shapes and sizes, and that's part of the joy of it, it's not a vagary to be managed, it's part of the joy of life. And, you know, we have a real responsibility, and as I say, we can model that in local government, and I'm glad my council does, and you know, the more of that the better. So I think I'll probably draw a line under that there, Joe, but just by saying that, you know, there's a lot for us to go at in this area. We will push the government hard, and, you know, in whatever ways we can do, and in whatever issues colleagues want us to raise, we will use the best as we can. But there's no better tool to do than to win power and to do this in government And I say that, and that's me. I intend to do it. Tulip intends to do it, but also people on this Zoom who I hope won't have been put off by what they saw with Luke's experience. That there will be at least a person, if not multiple people, in the audience today who will be in Parliament with me and Tulip as part of that next Labour government doing those things. I mean, that's what's at stake, and that's what I hope keeps our activism going and keeps our faith even in challenging times. Cheers, Joe.
Thank you so much, Alex. And I think that may be the first time, certainly a Labour frontbencher has spoken about the HIV restrictions on IVF and probably on the government side as well. So thank you so much for that in particular. It was great to hear. And also great to hear that there are such positive noises about reforming surrogacy and the adoption processes. I think it's so important to hear that. Now, in the audience tonight, we have lawyers, we have LGBT activists, we have general members of the public. So the questions that have come in are a bit of a mix. So we've got about 20 minutes to answer some of those. So I'll try and get through as many as I can. The first one I want to turn to is more about advice for LGBT people. And it says, what advice would you give to a single LGBT person in the way that they can best prepare before starting the journey towards surrogacy or adoption? I think I'll come to Andrew on that one first, and then perhaps Naomi.
I'll take the surrogacy limb, if I may then, Joe.
Yeah, please.
I suppose if you're looking at it from a surrogacy perspective, you need to think about what country you want to do it in. It's perfectly possible to do it in the UK. It's important to emphasise, which perhaps I think none of us have really touched on, that even though there is a prohibition on commercial surrogacy, altruistic surrogacy is fine. So you can have a surrogacy where reasonable expenses are given to the surrogate, but she can't be given, there can't be a commercial transaction whereby there could be a question about her ability to consent freely. So it's perfectly possible to explore, they're not really agencies, but they're effectively not-for-profit agencies, I use the word agencies, but they're not agencies, that are based in the UK, are reputable, such as Brilliant Beginnings and Surrogacy UK and COTS, who offer help and advice on what you can do here. If you decide you want to go abroad because you're worried about there being a lack of surrogates, or you're worried about the legal certainty kind of issues, you need to think about where you're going. Because if you establish where you're going, you then need to work out what the law is in that country. Because part of the problem that I see, and Charlotte will see and Naomi will see, is that people go to a different country and then they're not familiar with the law. It might be a country where there haven't been many surrogacy cases. And so you're potentially at risk of being exploited yourself as well as a surrogate. And so you also need to think about how that will impact your ability to come back to the UK and obtain a parental order. And the other thing, which again is an important consideration, and again, none of us here are immigration lawyers, but it was speaking for myself, but there's certainly a strong overlap with immigration issues, because you also need to consider how you get back to this country. So for example, people who go to the US, anyone born in the US, as everyone will know, automatically acquires American citizenship. And so it's fairly easy to get back to this country on an American passport, with the provision that you're going to apply for a parental order here. But you will not, for example, qualify for a parental order if you are not biologically related to the child. So it's not permitted in the UK to have what we call double gamete donation, where you use a donor sperm and donor egg to create an embryo. That's not permitted here. But in some states in the US, you can do that. So you could have that happen, but you wouldn't qualify for a parental order. One of the recommendations that the Law Commission has is that if there's a medical necessity, they would allow a parental order where there's no biological connection. But it's not even but that's only if you do it in the UK. And again, it's not even been enacted yet. So you really need to think carefully about practical things, about what the law is in that country, how you're going to get back here, to make sure that you can have the optimum legal relationship with your child. Because if you don't qualify for a parental order, it's not, there's no it means that you can't be recognised as a legal parent, which is quite significant, but there might be other orders that you can obtain that still give you status in relation to the child, and you might be able to adopt. But there again, there's sometimes there are prohibitions on adoption where it's happened abroad and where there may have been a commercial expense. So you need to think these things through quite carefully, and that's not to scare you or scare anybody in the audience. In fact, it's just being cautious. And I think as lawyers, because as Charlotte said, we're often seeing it in the worst case scenario because we've been called into a case. But you just need to exercise due diligence is the key phrase I would use, because the other factor I would just add is that I've seen it increasingly in international surrogacy cases, is that when I go to do these cases in the High Court, the judges are quite understandably are being very cautious when it concerns a jurisdiction, so a country where they're not that familiar, where there haven't been many reported cases. So the US, there are loads of cases that go to the US and people come back successfully. And of course, the US is sometimes, people are put off by that because of the expense. But if you go to a country where the UK courts aren't really familiar with surrogacy, they're going to want to make sure that you've checked things like who are the agency, what does the surrogate know, just to make sure that there's not been any kind of element of exploitation. So you need to consider carefully, if you're going to a country that basically isn't America or Canada, what steps are being taken by the agency. So due diligence is probably the key phrase I would say you need to adopt.
Fantastic. Thank you, Andrew. Naomi. Oh, so I think you're on mute.
Okay. Yes, I mean, obviously it's important when you're making such an incredibly important decision in your lifetime that you are fully informed about it. And there's much more ability to be able to get this information now with the internet and the various chat rooms and Facebook groups. Really, one of the most valuable things is to be able to talk to other families who've already gone through the process. And yes, you can reach out to, I mean, there must be LGBT networks and groups who will have people who've had the experience of it and will tell you of the high spots and the low spots, but at least you're going to be fully informed, well, hopefully fully informed when you go into the process. As Alex said about the assessment process, yes, it's got a bad reputation in a way, but I don't believe that love is obviously really important, but I don't believe that love alone is enough. These are children who come out of very inclement backgrounds, not through their own fault at all, and not necessarily through their parents' fault either. But it can affect those children's development, their health, and I think you need parenting plus skills to be able to be able to meet those needs. As I said, the introductory groups and the preparation groups should give you a sort of grounding in that. And then when you get involved, I mean, I think, yes, there's another matter, is that Alex mentioned that it's very intrusive in terms of going into a prospective adoptive family. Is intrusive. It asks, questions about your childhood and your parenting, which you wouldn't anticipate having to discuss with anybody. But I think that research has shown that if you have had difficulties or problems in your own upbringing, this doesn't mean that you can't adopt. It just means that these are issues that need to be addressed. Because if they're not addressed, the risk is that these trickle up, they bubble up when you're actually parenting your child and with the particular challenges that bringing up an adopted child can give. I've mentioned the sort of preparation groups for adoption. There's also independent components that once the home study is complete, it will then go to the adoption panel, which has all sorts of people on it. There'll be the medical advisor, social work advisors, adopted people, people who've adopted, and it's the independent component of the process. And the adopters, prospective adopters, would attend that panel and would be asked any additional questions, be able to give their own story. Yes, there's for social work practice. One can not rule that out. But if the whole process has been speeded up, it used to be endless. And I know that because I chaired an adoption panel of a national adoption agency for many years. And they've now, I mean, their practice was good, but it was too slow very often. And they've now brought in reforms. So it should be a 6-month process, 2 months for stage 1, all those preparation groups, and then 4 months for stage 2 of the home study assessment. And if the home study comes out as negative, there is an independent review body that prospective adopters can request a review called the Independent Review Mechanism. And they will look at the whole case again and make recommendations that then go back to the adoption agency.
Thank you, Naomi. I'm going to push on because we don't have long for questions. I want to turn back to surrogacy, particularly around how half of the surrogacy arrangements are being made outside of the UK. We've got some questions about that. So I'd like to come to Charlotte about that and then Andrew. I suppose what I'm looking at here is, do you think we are pushing too many LGBT people abroad because the law here just isn't fit for purpose? And because of that, do you think that essentially surrogacy is kind of the preserve of the wealthy if you want to get it right in law? I'll come to Charlotte first and then go back to Andrew.
Yeah, it's quite a controversial question, I suppose, whether it's something available for the wealthy. But no, I mean, entirely right. And, you know, one hopes that's not the case. But yes, I think given the fact that obviously this can cost a huge amount of money to go about international surrogacy arrangements. And Andrew's spoken about the importance of due diligence. And I think particularly if you wish to make sure that you do your due diligence as best as possible, and that may be by, for example, instructing a lawyer to walk you through the process, which one would ordinarily perhaps advise to do so, given the significance of the decision that a person is making or a couple are making, and all of the things, as we've already discussed, that could potentially go wrong. Those types of ways of going about international surrogacy, whether it's through legal advice or through payments and so forth, that it's certainly not cheap. So yes, potentially it does mean that it is only available for the wealthy. Now, I just say in relation to that about potentially a reform that could be introduced, and that would be to allow intended parents, I think, to be legal parents from birth, rather than the other way around and having to wait and go through the whole process to eventually become the legal parents from birth. I mean, obviously it's intended that they would be legal parents, and so having to jump through further legal loopholes is not only, I imagine, very stressful and anxiety inducing, but can put a lot of people off as a consequence, because it can seem like such a convoluted process to have to go through. And I know Andrew's spoken about the importance of a new pathway, and perhaps, you know, I'll hand over to him for him to expand upon that.
Yeah, I think that's a really good question. I think I've certainly seen it in practice. I recently had a case in the High Court where a same-sex couple had gone to another jurisdiction, to another country, and it had become quite difficult when they got back to the UK. And I think the quality really is that I think if you're going to do a kind of a Rolls-Royce international surrogacy, it means you tend to generally have to have money. And it does create this kind of two-tier system. And the cases that I commonly see that are difficult, and expanding it just beyond the LGBT plus community, it tends to be people who have, you know, scrimped and saved, they've remortgaged, they've done all sorts. They're not your Elton Johns who have been able to go to California and spend a lot of money. And so it just creates this two-tier system. And I think part of the law, as I said, part of the Law Commission's ambition is to try and reduce that, and also kind of effectively normalise surrogacy as a pathway to parenthood. And I think the proposals by the Law Commission do try to strike that balance by ensuring the certainty at an earlier stage, and knowing that there can be certainty, I suppose, that this is your child and that you will be recognised as such at birth. I think one of the complicating factors, and I think I saw a question in the chat about public law proceedings, so what we call proceedings where the state is involved, so social services, and they might become concerned about a case. And I've seen cases where, and involving same-sex couples, where the local authority have got involved in relation to a surrogacy, and they've misinterpreted it as child trafficking. And so that becomes an issue where the local authority then saying, well, actually, perhaps this child should be removed from your care and placed in temporary, in foster care while we undertake investigations. And so you get this double whammy of not only have you had this couple, this same-sex couple, who have gone to another country to undertake surrogacy where it's been a bit precarious, a bit tricky, and they come back to this country and then they're confronted at the border with questions about whether this is trafficking, when actually it's, if they had been a couple who'd gone to California, it probably wouldn't have happened. And so that, again, it's a pitfall and it's a risk. And so, and again, because some local authorities aren't as au fait, not even some, most, I would probably say, aren't really au fait with how surrogacy operates, it sends off this kind of red alert, and then you're then confronted with a situation where the child might be removed from your care temporarily pending assessment. So it can get quite difficult. And so I think, if the Law Commission proposals are enacted, it would at least make it more inclusive to ensure that same-sex couples can use surrogates in the UK without having to feel they need to go abroad.
Thank you, Andrew. That's really interesting. Because we're so tight on time, I want to go to Naomi quickly for this next question and then quickly get to Alex. I know you've got to shoot off at exactly 1:15. So Naomi, quick question is, you've talked a lot about needing to take into account parents' considerations in regards to LGBT adoption and fostering. Do you think there's enough protection for potential LGBT children or who grow up to be LGBT who are placed with families who potentially may not be so supportive in that environment? Do you think there's enough there?
Sorry, I don't quite understand what families are the ones that would be less supportive.
Talking about, so I suppose, do you think there's enough in the adoption process that teases out whether people would support an LGBT child who grew up to be LGBT?
Well, the home study process is pretty robust. And as I say, there's variations in social work practice. There's also variations in the postcode lottery of local authorities. I mean, if you're living in one of the big metropolitan authorities, then you're much more likely to get a more knowledgeable, approach to the whole thing. That's not saying that non-metropolitan ones would not, but it is more of a risk. It's why in any sort of complicated case I do a lot of international adoption, I would always want to issue a case, if I possibly can, in London, because I know the judges at the Central Family Court are experienced. They're not panicked by the international nature. But as I said, the home study process should help prospective adopters to look at the challenges there might be, to be able to address and think about how they might deal with prejudice that their adopted children could encounter, and give them pride in their background.
Thank you, Naomi. Alex, I just, before you go, want to issue an invitation to you, both from LGBT Labour and from the Society of Labour Lawyers, to carry on this discussion in more detail outside of an event, because there's clearly so much work to do in this area, and I think something the Labour Party could really lead on in the future. So we'd love the opportunity to work with you in the future.
Absolutely.
Work for you. Fantastic.
Great.
Well, thank you very much, everybody. Thank you to the fantastic panel we've had this evening. I want to say particular thanks to both LGBT Labour and the Society of Labour Lawyers. Just to let you know, you can join both LGBT plus Labour and the Society of Labour Lawyers on their respective websites, either as members or as supporters. And for the rest of LGBT History Month, LGBT plus Labour has more events coming up, including an event tomorrow on trans rights, feminism and transfeminism, at 6 p.m. and further details are available on the LGBT Plus Labour website. But just to say thank you all once again for coming, both panelists and audience, and we hope to see you soon. Have a great evening.
Thanks.